Let's continue. We're going to look at Articles 29 and Articles 30. We've already done the types of writs and their applications in 32. After this, we'll move to the doctrine of basic structure and the doctrine of harmonious construction. So let's start. Article 29, the title of the article says, the protection of the interests of minorities. It has two subclauses. Questions from here are extremely unlikely from the exam point of view for multiple number of reasons. First, there isn't a lot that happens here. And two, if you understand what basically this is supposed to tell you, this is more than enough. So, it says any section of the citizens, which means this is a right only and only available to citizens and not to foreigners. So any section of the citizens residing in the territory of India or any part thereof having a distinct language, script or culture of its own shall have the right to conserve the same. Now this explains to you that there is no defined what is called definition. There is no defined criteria as far as minorities is concerned. People use the term minorities rather loosely, and that's perfectly fine because constitutionally speaking, there is no defined meaning of the word minorities. Now, when we look at Article 29 Clause 2, we'll be able to understand what is it that we are referring to. No citizen, again a right only available for citizens, shall be denied admission into any education institution maintained by the state or receiving aid out of state funds on grounds only of religion, race, caste, language, or any one of them. A simple article which basically explains to you that this is exactly why Hindus can study at the Aligarh Muslim University and Muslims can study at the Banaras Hindu University. Hindus can also study at the Jamia Millia University in Delhi. Okay, so this is largely how this is. This is largely how your Article 29 is. But what you must understand is the fundamental principle of Article 29 is relativity, which means in a given geographical area, in a territory, if your language, your script, your culture is in a lesser fraction, then you're automatically a minority and you have the right to conserve them. Now, what does it mean when you say that you have the right to conserve them? It means you can have institutions, you can have programs, you can have initiatives, you can have awareness sort of policies and so on and so forth. Now, Article 29 is accurately supported by Article 30 because the fundamental way to conserve any of these attributes is to ensure that people get educated in these attributes. So let's understand what they are. So when we look at Article 30, what does it say? The right of minorities to establish and administer educational institutions. All minorities, whether based on religion or language, which means here it specifies religious minority or a linguistic minority, which means only religious and linguistic minorities have the right to establish educational institutions of their choice. Now, this could be a madrasa, this could be a higher education institution. You have the right to do so. And not only this, when you have the right to do so, you will be supported by the state in terms of funds, in terms of resources to essentially make sure that your institutions run rather smoothly. Now, there was an amendment which was made here, and the amendment said, in making any law providing for the compulsory acquisition of property of an education institution established or administered by a minority referred to in clause 1, The state shall ensure that the amount fixed or determined under such a law will not restrict or abrogate the right under that clause, which basically means if the government has to acquire your land and your land is the land of a religious or a linguistic minority institution, the amount of money that is going to be given to you, because you have to compulsorily sell your land to the government, that will not be a bad number, that will not be an unfair number, and it will help you further propagate your religion and your language. And the reason why this particular clause 1A was added was in the context of the Keswananda Bharti case, because it dealt with acquisition of religious property. So if you actually see the footnote, and it says the 44th Amendment 1978, which is after the Keswananda Bharti case of 1973. And I'm going to come to that in just a fair bit of time. Now, the state shall not, in granting aid to educational institutions, discriminate against any educational institution on the ground that it is under the management of a minority, whether based on religion or language. Which means that if the state, through its budget, through its welfare schemes, through its policies, have to give some financial support to minority institutions, it should not be based on any religious or linguistic discrimination. Now, if you compare the discrimination provisions which are mentioned under Article, Article 29 and Article 30, we will be able to understand that these provisions are therefore largely wide in nature and therefore are able to be comparative in nature. So let's look at it from that point of view. See, when you look at the discrimination variables which are given in Article 29, it says religion, race, caste or language. But this is largely from a citizen point of view, that the citizen cannot be discriminating on religion, race, caste, language or any of them. It again, interestingly, does not mention gender. It does not mention residence or domicile or any of those variables. But if you compare the discrimination variable here in Article 30 Clause 2, it explains to you how it is on the basis of just religion and language, because Article 30 primarily deals with religion and language. Okay, so that is something that we must be able to get right. That is something that we will be able to sort out in the larger system that we have today. Right? So these are your Articles 29 and 30. You would have heard of several institutions such as Speak Mackay, which was an institution set up pan-India to promote folk arts and folk music and folk dance. And they performed at several schools across the country to promote the language and the dances and the music from the parts of the country which often don't get the national platform they truly deserve. Right? So this is what is Article 29 and this is what is called Article 30. Now this takes care of your basic understanding of fundamental rights. We've also covered some of the analytical issues arising out of 14, 19 and 21. What is remaining now is perhaps the most interesting story which changes the very destiny of the nation that you and I are so proudly a part of. And we're going to now move to that part of layer 2 where we will be understanding what is largely called the doctrine of basic structure. Now, we're essentially going to be studying two doctrines. One, of course, is the doctrine of basic structure. Okay. The second is the doctrine of harmonious construction. And to understand both of these doctrines, we will have certain players involved, certain attributes involved, certain technicalities involved, right? So one of the first things that we're going to be looking at is from a background of it is an article called Article 13 Clause 2, which basically says no law can violate a fundamental right. No law can violate a fundamental right. That's Article 13 Clause 2 for you. Then we will have Article 368. And here under Article 368, this is nothing but the Parliament's power or the Parliament's procedure to amend the Constitution. To amend the Constitution. These are the two background provisions that are going to be used to understand the basic structure and the harmonious construction doctrine in an amount of detail. Now, you must understand there is an inherent conflict. The conflict is, if no law can violate a fundamental right, then the Parliament cannot make any law to change fundamental rights, because a constitutional amendment is nothing but a type of a law, because a constitution is also a law. This means fundamental rights then become airtight and nobody has the powers to change fundamental rights, and our constitution becomes rigid in that sense. So the fundamental conflict, the protagonists of this story are of course Articles 13 Clause 2 and Articles 368. This is the first set of protagonists. The second set of protagonists are going to be your fundamental rights. These fundamental rights pertain to Articles 14, 19 and 31. There will be several amendments which will be made to 31. So 31A, B, C, so on and so forth. And particularly Article 19 Clause 1 Clause F. Right? Now, Article 31 is your primary right to property, and this is supported by Article 19 Clause 1, and both of these over a period of time will be eliminated from the Constitution. We'll come to that later, but these are basically the set of fundamental rights that are going to be called into question, that are going to be understood in a certain set of concept as far as our rights are concerned, our ecosystem is concerned. So I hope this is clear. I hope we understand what the basic is, what the basic premise is. So this is going to be your plot 1. This is going to be your plot 2. This is actor 1, actor 2 and actor 3. They are going to have some story here. They are going to have some story here. And you're also going to see some directive principles also involved. Now the directive principles that are going to be involved are going to be 39B and 39C, which primarily refer to the socialist principles, wherein the state should do something to prevent concentration of wealth, which is 39B, and C is to try and provide for equal distribution of resources. So in our first doctrine, we're going to see 1 and 2, which are going to be applied. And then in our second plot, in our harmonious construction, we are going to see a larger fight between 2 and 3, and both of these plots will combine at a midpoint. It is basically, if this is plot 1, this will be plot 2, they will meet at a common point, and then there will be a climax to this story. Okay, there will be a climax to this story. I'll draw the whole diagram for you, and I'll expect you to also keep understanding the diagram, but this is basically what is going to happen. So this is the plot of movie 1, this is the second plot of the movie. Both of these plots will have a meeting point, and this is going to be the climax or the suspense of the movie, and both will eventually lead to the same destination. Okay, and these are the various actors: 13.2, 368, fundamental rights and directive principles. Okay, I'm going to give you 2 minutes to take a note of this, and then we will begin. All right. Let's look at it as if we are looking at a movie. Now, a movie will often have some sort of a prologue, right? Or some form of a backstory. This backstory will then lead to the formation of a plot. In our case, we've got 2 plots, plot 1 and plot 2. And then both of these plots will merge, and then what we will have is the climax of the movie, the suspense or the end of the movie, right? So we're going to study it like we are, English literature students trying to understand the whole concept of, a movie, like we're doing a movie review. So let's understand the prologue, and let's understand the prologue which gives birth to plot number 1, which is the doctrine of basic structure. Or let's understand the backstory, right? The backstory is that we became independent in 1947. The backstory is that from 1947 till about 1952, the Constituent Assembly converted into what was called the interim parliament, right? and we had an interim government as an outcome of the interim parliament. And they had a mammoth task to figure out what can we do to solve the issues of our country, right? Now, the prologue is, let's look at an analogy. Let's look at an unrelated kind of an example, okay? The unrelated kind of an example that we are referring to is this. Suppose you are an engineer who is working at an IT firm. Suppose you are an engineer working at an IT firm. This is your occupation, and you are the worker, you are the labor here, right? Now, your IT firm may not give you a proper cabin, may not give you proper benefits, may give you some extra benefits, whatever the case might be. But the one thing is for sure, that every engineer is going to be given a laptop or a computer so that they can do their job. And this laptop or a computer is the asset. And if you notice, the worker, the asset, and the occupation are equally distributed. Every engineer will have access to at least one laptop so that they can continue to do their job. Now, unfortunately, this is not the largest profession in the country. Most Indians, contrary to popular belief, are actually not engineers. Most Indians are actually farmers. And agriculture is India's highest or largest sector, which means, by largest sector I mean by the number of people who are engaged in agriculture, not by the terms of its contribution to GDP. And the sad reality is that even today, despite the fact that most Indians work in agriculture, we still have not been able to have a substantial contribution of agriculture to India's GDP. But that's besides the point. So here also, the farmer is the worker, agriculture is the occupation, and the difference here is that your asset now becomes land. And unlike here, where every engineer is getting some or the other form of a laptop, every farmer does not have access to land. And therefore, landless farmers or landless laborers are a dark reality as India is born into independence. Now, unlike engineering and IT firms, where if, let us say, there are less laptops, you can manufacture more laptops. Here, you cannot manufacture land. Land, unfortunately, is a finite resource. It means the only option that you have is that from the people who have extra land, land must be taken from them and must be given to the people who don't have land, have-nots. And this process becomes eminent and is therefore called land redistribution or land reform. Land redistribution or land reform. Okay? Land redistribution or land reform. Clear? So, it was one of our first and primary problems that we had to solve. This had to be the immediate attention of the new to office policymakers in these years. Remember, our first ever general elections will only happen in 1952. So the first ever Lok Sabha, so to speak, is actually from 1952 to 1957. Right now, the Constituent Assembly is doubling up as the interim parliament. And therefore, we understand that it was an absolute necessity of the government to think of substantive ways to solve this issue because of countless policies and a basic feudal structure to Indian society. A large portion of land in India was owned by a very small section of people who were also called zamindars, who were also called landowners, right? So this now we understand that the government's objective therefore becomes land reform. But the objective isn't as simple as it seems. It isn't at the stroke of a pen. It's because the parliament cannot make any law on this kind of a land reform that we are referring to, because land is in the state list. Because land is in the state list. And because land is in the state list, you as the parliament have absolutely no locus whatsoever, no standing whatsoever to make a national land reform law. And therefore, the only people who can make a land reform law like this are the state legislatures of India. The only people who can make a law like this are the state legislatures of India. Because if you open Schedule 7 and you read the 6th entry, you will find that land is a state subject. But there is a blessing in disguise. There is a silver lining at the end of it all. We have just become independent. There is a uniform national pro-Congress fervor. People are excited, people are thrilled, everybody has a national sentiment, and people are equating the freedom of the country to a very large degree to the Indian National Congress. So as a result of this, when elections are held at state legislative assemblies, most state governments also happen to be of the same political parties as the center, which is the Indian National Congress. So all that the parliament had to do, or all that the political leadership had to do, was get in touch with your regional governments, tell them that we need to make land reform laws. And what are these land reform laws? These land reform laws, which will be created state by state wise, they are nothing but, suppose this is the state X. In this state X, let us say, for example, nobody can own more than, 100 hectares of land. Just a random example. If you own 120, the government is going to buy the 20 hectares from you. It's not that the government is going to snatch the land from you. It is going to buy the 20 hectares from you. It does not matter whether you want to sell the land or not sell the land. You have to compulsorily sell the land to the government, and you will be paid a fair price for the same. And these were the instructions which were issued by the central political leadership. These were the instructions that were issued to the central by the central political leadership to the respective state legislatures, whoever had the Congress majority, and they were asked to make their own state specific laws because they had the powers to do so. And several states jumped at the bandwagon. Several states jumped at the bandwagon. Now, what happens? Now, we are talking about the early 50s, which means we had Bihar, we had Bombay, Maharashtra did not exist at that time. We had Bihar, we had, for example, Bombay, we had Madhya Pradesh, we had Uttar Pradesh, right? We had Hyderabad. All of these kind of states started enacting land reform laws. Now let's understand what happens after. You see, let us say Bihar enacts a land reform law. It says you cannot have no person can own more than, let us say, 50 acres of land. Additional land will be compulsorily purchased by the state. Okay? Will be purchased by the state. Now, this is a law. We know that Article 13, Clause 2 says, no law, doesn't matter if it's a central law or a state law, can violate a fundamental right. Now, this at the end of the day is a law. Let's call it Law 1. Right? So the question is this Law 1 violating any fundamental right? And that is where we look at the fundamental rights that we have. We had a direct right called Article 31, which was India's primary fundamental right to property. Primary fundamental right to property. Second, we had Article 19, Clause 1, Clause F, which also gave the citizens the right to reside, dispose of, or acquire any property that they felt like. So, an additional fundamental right to property. Okay? And if you think about it, this law is discriminating people on the basis of land ownership. This was never a criteria in any of the rights. This law was creating two kinds of classes of people. First, the people who had land, and second, the people who didn't. And if you had land and you had some extra land, your land would be taken away from you and given to people who don't have land. So the law is treating people differently on the basis of land ownership. That was never a reasonable classification or a reason as to why you could differentiate on equality. So Article 14 also becomes slightly compromised. And if you think about it, it is the same Constituent Assembly which had so vociferously, so adamantly added these provisions to the Constitution, because for India, which was a colony, land was the absolute essence and the life of the people, which is why the makers of our Constitution had to really secure land for the people. But these three fundamental rights were being violated of the landowners. So people who had extra land, their fundamental rights of 31, 19 clause 1F and 14 were being violated, which meant that the fundamental rights of 14, 19 and 31 broadly of the landowners were arguably violated by the respective state land reform laws. That means you have the right to challenge the constitutionality of these laws due to Article 13 Clause 2 at the Supreme Court under 32 or your respective high courts under 226. So, several landlords, several landowners filed petitions at various courts challenging these land reform laws respectively. I have simplified this for you. Okay, I'll give you 2 minutes. You can take a note of this.
Will be doing it.
All right. Now the first move has been made. The political leadership at the center, the government at the center, is visibly disturbed. They want to reform the country. They are heavily influenced by socialism. And here you have these petty landlords questioning such a moral and such a well-intended policy of the government just because it seems to be violating a fundamental right. Now the government says, where are your fundamental rights? Everybody says, the Constitution. Then let's change the damn Constitution. So the first Constitutional Amendment Act of 1951, which we've referred to in a lot of other fundamental rights discussions, this amendment introduced Articles 31A and Articles 31B. Articles 31A very clearly says, if the government acquires a land, no fundamental right is violated. A straight up reply. If the government acquires land, no fundamental right is violated. None at all. And then what did the government do? They said, you know what? All across this country, these guys are setting up these cases against us. You know what? We'll set them straight. We'll go to the market. We'll get, we go to the market. Please don't disturb me in the middle of a discussion. This is a very intense discussion. Have some manners. Now, we'll go to the market. We'll get a big bag box. And in this box, we will add all these land reform laws. And what will be the best feature of this? That whatever laws are inside this, whatever laws are inside, these cannot be challenged in any court. And we will call this box the 9th schedule. Ab ukhad do jo ukhaadna hai. You can't challenge these laws. This was done by the First Amendment 1951, and this amendment also happened by the interim parliament, which is basically the Constituent Assembly. And the irony is, the same people who added the rights to property are the very same people who are adding restrictions to the rights of property. Very interesting. The same people who added the right to property are now adding the restrictions. And we all know India's first PM was Jawaharlal Nehru. Why am I telling you this? Because just a few years ago, barely 5-6 years ago, there was a previous year question in the prelims, which was, who was the Prime Minister of India when the 9th schedule was inserted? The answer is Jawaharlal Nehru. And this is your answer. Okay? This is your answer. Now the prologue is over. Now the prologue is over. The government has created a shield. Shield number 1. If the government acquires your land, there's no fundamental right violation. Shield number 2. Any of these previous land laws, we've put them in a special place and you can't take them to court. The courts don't have the power to look into the constitutionality of all of this. This is the prologue. This is where the journey for plot number 1 starts. Now, all we've got to do is simply listen to a story and understand what happens in that story. Okay? So, plot number 1, starts from here. Plot number 2, which we will come to later, will meet plot number 1 at a point of time. And plot number 1 is called the evolution of the doctrine of basic structure. The doctrine of basic structure. It starts with certain land reforms, leads to the first Constitutional Amendment Act of 1951, wherein Articles 31A and 31B are added, and 31B also added the 9th schedule. 31B also added the 9th schedule. Okay, so this is the story. This is how it has to be done. Okay, understood this, right? Now, in the same case, in the same year itself, in 1951, there was a landlord. There was a landlord. His name was Shankari Prasad. His name was Shankari Prasad. Now, his land was also taken away. So he went to a lawyer and he said, "Isn't this unfair? They've taken my land away, but I didn't want to sell it in the first place. Why are you forcing me to sell the land?" Then the lawyer said, "Let me have a look." He said, "You're right, Mr. Prasad. You're absolutely right. But there's a problem. The law which gives the government the powers to compulsorily buy land from you has been provided some form of immunity. And the immunity is that we cannot challenge that law at any court of the country." Perplexed was Mr. Shankari Prasad. He told his lawyer, "Please find some way out. This means I have to compulsorily sell my land. What is the whole point of it?" Then the lawyer said, "Let me think. I understand that I cannot challenge what's inside the 9th schedule. But nowhere does it say that I can't challenge the 9th schedule. I can't challenge what's inside the box, but I can certainly challenge the box." And that is how the Shankari Prasad case versus Union of India came to being in 1951. The first case with respect to the 9th schedule. Now, in this case, just to give you a little bit of context, just to give you a detail of arguments. So you had Shankari Prasad, versus you had the Union of India, which is nothing but the government. So there were lawyers here, there were lawyers here. Now, in the Shankari Prasad case, this is what your arguments eventually ended up being. The argument was, Shankari Prasad's lawyer said, Article 13 clause 2 says no law can violate a fundamental right. Now, these landlords or these land reform acts are violating my fundamental right. And this 9th schedule immunity that you have given is also violating my fundamental right to approach the Supreme Court or the High Court under 32/226. No law, no matter what the law is, gives you the right to take my fundamental right away. Right? Makes sense? The government said, hold on. Your fundamental rights exist because they are in the Constitution. And under Article 368, we, the Parliament, have the powers to change anything in the Constitution. And this anything includes fundamental rights. This anything includes fundamental rights. Equally compelling arguments. Both sides had a very strong merit. Now, the Supreme Court gave a very interesting rationale. The Supreme Court did exactly what we all do on a Friday evening with a little glass of lemon water, neat. We question the purpose of life. That's exactly what the Supreme Court did here. The Supreme Court said, fair enough, you do have a point. But see, Article 32 says, no law can violate a fundamental right. No law can violate a fundamental right. The question is, what do you mean by law? The lawyers of Shankari Prasad were perplexed. They said, why are you complicating this? A law is anything which is legally enforceable. Then the Supreme Court said, no, it's not that simple. Who makes that law? What kind of a law that we are talking about has a very strong role to play. This is no normal law that we are referring to. We are referring to the Constitution of India. We are referring to the Constitution of India. And this Constitution of India was drafted by the Constituent Assembly. This is no ordinary law. This is absolutely no ordinary law. So it can't be treated like an ordinary law because the Constitution is your highest law of the land. And in the Constitution, the fundamental rights are higher than the highest. Because you can directly go to the Supreme Court for it. No law apparently can violate, no law can violate a fundamental right. Which means tomorrow the Parliament wants to add a fundamental right. You will also come then and say, no, they can't. Are we supposed to have a rigid constitution? Are we supposed to have a narrow constitution? Are we supposed to have such a short-sighted constitution? So, the Supreme Court did what we all do. That there are two ways to live life. Either live or let live. So the Supreme Court said, there are two kinds of lawmaking power. Two kinds of lawmaking power. Constituent lawmaking power and ordinary lawmaking power. So a constituent law is any law which is changing the constitution under Article 368. An ordinary law is any other lawmaking power. And this constituent lawmaking power lies exclusively with the parliament. Exclusively, because 368 says so. So can the parliament change the constitution? Yes. Can the parliament change anything in the constitution? Yes. And can the parliament change any fundamental right that they want to? Absolutely yes. Shankari Prasad faced defeat. Shankari Prasad faced defeat. And they said, these laws that you are talking about, this is an ordinary law. Because if a constitutional amendment can't violate a fundamental right, it can't change a fundamental right. So that is why this means ordinary laws can't violate a fundamental right, and constitutional amendments are not quote unquote law as per the definition of law only for Article 13 Clause 2. And let me tell you, boys and girls, this is still the case today, even on the 3rd of February 2021. If I ask you, are constitutional amendments law as per 13 Clause 2? The answer is a clear and a strict no. So, under the Shankari Prasad case, two things happened. Parliament can change all fundamental rights, and two, constitutional amendments are not law. Clear? Just see how this land reform issue suddenly becomes a fundamental rights issue. Because that's how you evolve. That's how a simple challenge to the constitutionality of the Aadhaar card in 2017 gave birth to the right to privacy judgment of 2017. Right? A simple valid constitutional challenge to the Aadhaar card in 2017 gave birth to the Puttaswamy judgment of right to privacy. Because Supreme Court is a conceptual court. They want to get into the feel of things, into the pulse of things. They don't care about land and a person's livelihood. They care about legacy. Creating a legal principle that is going to survive for years and years to come. For years and years to come. And this is how Shankari Prasad happened. Now, of course, in the Shankari Prasad case, it is abundantly clear that the government won. And whenever you win, your confidence becomes overconfidence. And the government said, now that the court is on our side and we are almighty as the parliament and we can change anything in the constitution, no matter what it is, let me enact the 17th constitutional amendment of 1964. The 17th constitutional amendment of 1964. And here they added a lot more laws, added more and more state laws to the 9th schedule. Okay? And the two states that they added here were Rajasthan and Punjab, among others. And the next cases come from Rajasthan and Punjab. And this is where, in 1967, another landowner from Rajasthan called Sajjan Singh Another landlord from Rajasthan called Sajjan Singh did the exact same thing as Shankari Prasad. Said Sajjan Singh versus the state of Rajasthan of 1967. Okay, of 1967. Again, the same arguments. But there was a very small change in these arguments. Here, say the lawyer said, boss, you are right. If I go and argue the same thing again and again and again, then that means they are going to reject the same thing on the same grounds. Now, you see, I'd like to bring in some new information here. The small information is, if you are challenging the constitutionality of any law, then the Supreme Court sets up a 5-judge bench. That minimum 5 judges are required for you to hear the constitutionality of a law. Minimum 5 judges. So, in the Shankari Prasad case, you had 5 judges, and you would require a minimum 5 or more in the Sajjan Singh case also. In the Shankari Prasad case, all the 5 judges said the exact same thing. And here also, okay, here also, in the in the Sajjan Singh case also, 5 judges, and they said the same thing. But the difference is, what did the lawyer argue? The lawyer can't argue the same thing here. The judge will throw the case out. That my brother judges, because we didn't have a lady judge at that time, my brother judges just about 10-15 years ago told you, no, why are you here? For the same issue. Then the lawyer said, no, sir. I am here because I have a new perspective. And that perspective is that it is violating procedure established by law. It is violating procedure established by law. How can you change this without the consent of the states? How can you make the First Amendment happen without the consent of the states? Property is a land matter. The court said no. Fundamental rights don't require state consent. It's not in the constitution. So bye-bye. There you go. Case dismissed. And here also, the same state as Shankari Prasad. Exact same judgment. The parliament can make any change to any fundamental right, and the parliament can make changes to all fundamental rights, and constitutional amendments are not law. Things are boiling. The mood is changing. And now, we are going to start with the next milestone. A milestone which is going to affect plot 1 and plot 2. And plot 2 is going to meet us here. You can take a 5-minute break, freshen up, and we'll start with this. I'm sorry if you can see I'm very excited about this. This is one of my favorite topics to teach. No matter how many times you ask me to teach it in a day, it's just beautiful. So yeah, we'll come back after 5 minutes. You can take a 5-minute break for this. Thank you. There's nothing that succeeds like success, and there's nothing that kills more than overconfidence. The government was on a high of success, a high of a collaborative sort of an environment with the Supreme Court. The judges were giving judgments which favored the government. Okay? Right? Now, this is where the tides change. An extremely wealthy landowner from Punjab called Golaknath challenged the law in the Supreme Court. Same year, 1967. This time, this was 1964, I'm sorry. And this time, instead of 5 judges, you had 11 Supreme Court judges. Instead of 5 judges, thank you. Instead of 5 judges, we had 11 Supreme Court judges. One of India's greatest lawyers, Nani Palkiwala, the courtroom genius, as he's often called. He was a lawyer who was also, an ambassador of India to another country. He was asked to assist in the matter, and he played a very small role, but that is how he became a part of this process. He plays a lot more significant role in the Keswananda Bharti case, but he made a 2-minute argument here. But the Golaknath case, the case which introduced Nani Palkiwala as a constitutional genius, and that's why there's a book called The Courtroom Genius by Nani Palkiwala, is written on him. Now, in the Golaknath case, the Supreme Court took a very practical opinion, woke up on a Saturday morning after the Friday evening and said, "Boss, what are you talking about? What is this ordinary law, constitutional law, constituent law? A law is anything which is enforceable. A law is anything which is enforceable. So how do you suddenly say that a constitutional amendment is not law?" And the Supreme Court reversed all their previous decisions. The Supreme Court reversed all their previous decisions. The Supreme Court overruled Shankari Prasad, overruled Sajjan Singh, overruled all the previous issues that had happened. And in Golaknath, the Supreme Court said, "Boss, nothing doing. The Parliament cannot, under any circumstances, make changes to fundamental rights. They're supreme for a reason. There is no such thing called a constituent law. Nobody can touch a fundamental right. And this entire process is unconstitutional. You can't restrict the fundamental right to property. It has been guaranteed by the makers of the Constitution. You want to change it? Call the makers of the Constitution. Dig your graves and wake them up from their death and then ask them to change this. You and I don't have the constituent power. The constituent power, if it existed, would have existed with the Constituent Assembly. So, the Parliament cannot touch fundamental rights. 13 Clause 2, constitutional amendments are very much law. But they also applied an American legal principle called the Doctrine of Prospective Ruling. The Doctrine of Prospective Ruling. Okay? The Doctrine of Prospective Ruling, which means all Supreme Court judgments or all court judgments will always be from the current date or the date after. Supreme Court judgments can never be for a back date. So even when Golaknath won, he didn't get his land back. हार के जीतने वालों को बाजीगर कहते हैं और जीत के हारने वालों को गोलकनाथ कहते हैं. The Supreme Court said this is wrong, the government can't acquire land. But sorry, Golaknath, this will apply to all future acquisitions of land. All future acquisitions of land. Not what the government has already done before. So Golaknath, of course, went with a sad face. Let's not forget the year 1967. The Prime Minister of India was Indira Gandhi, and she doesn't take defeat lightly. She said, fine, you've given an interpretation to the Constitution, I'll change the damn Constitution. I still have the powers to change everything else in the Constitution. You've asked me not to touch fundamental rights, right? I won't touch them. But I will make certain amendments to the Constitution. Certain amendments. And the first amendment that they made was the 24th Constitutional Amendment of 1971. And in this amendment, they directly overrule Golaknath. They directly overrule Golaknath. And they say that, boss, Golaknath said no, constitutional amendments are not law. Till now we were playing in interpretations. Now I am writing it in the Constitution. In black and white, in text, in spirit and in form. I'm going to insert a new subclause to Article 13 and I'm going to say constitutional amendments are not law. And I will also make the requisite changes to 368. I'll add another subclause 4, not important for your exam. And I will say that the Parliament can change anything in the Constitution, and that has nothing to do with 13 clause 2, so that you have a watertight provision. A watertight provision. A direct counter-attack to Golaknath. A direct counter-attack to Golaknath. And in the same year itself, she added the 24th Amendment of 1971, wherein they added 2 more state land reform laws. 2 more state land reform laws. And one of the states that they added was Kerala. One of the states that they added was Kerala. And that, ladies and gentlemen, gives birth to the Keshavananda, not Keshavananda, Keshavananda Bharati versus State of Kerala, 1973. A 13-judge bench, highest ever recorded in the history of the country. A judgment which is one of the lengthiest written judgments in the history of the country. One of the lengthiest written judgments. 800 plus pages, 4 lakh plus written words. Each of these 13 judges gave separate opinions. For the first time and the only time in history, the Supreme Court had to officially release a summary of its own judgment because this was too long. A 400-page judgment was too long to fathom. It is very interesting because of the political circumstances this judgment comes in, because emergency was just around the corner. It was a very important judgment because it was creating a shift in the power from the parliament to the courts with what it is going to do. And Nani Palkiwala argued the doctrine of basic structure. He said, and he told the Supreme Court, that, my lords, on one hand, we have to balance the flexibility, the evolution of the Constitution. And on the other hand, we have to protect the spine, the soul of the Constitution. And that can only happen with the doctrine of basic structure. And don't think this is an Indian innovation. The doctrine of basic structure for the first time was used in Germany and thereafter in Japan. So we used that idea and we argued it in Keswananda Bharati. And in Keswananda Bharati, the court basically tried to balance it all. Keswananda Bharati said, you are right. I cannot stop the parliament from making changes to fundamental rights. Otherwise, we will never evolve. So I am overruling Golaknath. And I'm saying that fair enough, you're absolutely right. Constitutional amendments are not law as per Article 13, Clause 2. You're absolutely right. Absolutely. No questions asked. The parliament can make any change to the constitution as it feels like. Any change. But we are going to create the doctrine of basic structure. A set of ideas, a set of principles that courts after this, courts after this will keep telling you what is basic structure and what is not basic structure. They'll keep giving you through various judgments, parliamentary democracy is basic structure, preamble is basic structure, secularism is basic structure, sovereignty is basic structure. They'll keep telling you these things. But we are creating the ecosystem for them to tell you. A summary of this judgment was created. 2 judges refused to even sign this summary. One of the biggest criticisms of this judgment is that nobody still knows exactly what the judgment says because there are 13 different opinions. This is the highest ever bench set up in Supreme Court history. We've never had more than 13 judges sit together on a case. Never. And then the Supreme Court said, you know what? Same doctrine of prospective ruling. Whatever has been added to the 9th schedule before 1973, fair enough, we will not touch, we will not challenge, we will not get into it. But anything added to the 9th schedule after 1973, and if it violates the basic structure principles, we are going to strike it down. And we are going to strike it down. And how? Understood this? Clear? Indira Gandhi was furious at this judgment. Because now we are entering into an era of judicial supremacy. Emergency gets applied. She introduces the 42nd Amendment of 1976. Tries to do the exact same thing as she wanted to do for the 24th Amendment. See, 2442. History repeats itself. History repeats itself. In the 42nd Amendment, she tried to add a clause to Article 368 and said any amendment to the Constitution will be immune from judicial review. Any amendment to the Constitution will be immune from judicial review. Then another case happened called Minerva Mills versus Union of India in 1980. This is the only case which has nothing to do with land. This case also has a lot of reason for our second story, which we'll come to later. This is about challenging nationalization of industries. Okay. This Minerva Mills overrules the 42nd Amendment, this provision. That no, judicial review is basic structure, boss. Judicial review is basic structure, and you can take anything and everything to court if it's a violation of basic structure. And a few years later, in 2007, in the I.R. Coelho case, the Supreme Court held that any amendment or any addition, even before 1973, that can also be challenged in the Supreme Court. Not only after, but also before. So today, anything which is in the 9th schedule, if it violates basic structure, can be challenged in a court of law. Tamil Nadu, which has a reservation policy of more than 50%, cannot be challenged in the Supreme Court because that reservation law is in the 9th schedule and reservation is not basic structure. Okay? Basic structure was also used during the emergency. When Indira Gandhi won her election against Raj Narayan, and Raj Narayan challenged her election victory at the Allahabad High Court, because election petitions are challenged at the at the respective High Court, and the Allahabad High Court stayed her election and said no, you could have not won the election because she had used government machinery for campaigning, and that is an electoral offence. That is an absolute electoral offence. So now the PM of the country was no longer an MP. She immediately went on appeal to the Supreme Court. The Supreme Court said, fine, we are staying the Allahabad High Court judgment. You will be the Prime Minister. You cannot vote in the Parliament. You can't speak in the Parliament. You can be present in the Parliament. And that is it. And that is it. Humiliated as she was, the second she got the Supreme Court order, the president at that time was Fakhruddin Ali Ahmad. She imposed a national emergency, put restrictions on media. Remember some of the laws that we discussed during Article 19, they all emanate from an emergency time. The media was not allowed to report on court judgments. And then she tried to pass a very naughty amendment, a very, very naughty amendment called the 39th Amendment of 1975, wherein she said that the election of the president, the vice president, the Lok Sabha speaker and the PM cannot be judicially reviewed. The Supreme Court shut it down, said, what is wrong with you? What is wrong with you? Parliamentary democracy is basic structure. We cannot have you immune yourself from an election. The first ever application of basic structure is to her election itself. Ladies and gentlemen, this is the case Ananda Bharti case. Okay? Understood? Now, correlated with a lot of polity that you have studied, you will see a lot of restrictions to fundamental rights imposed here. You will see a lot of restrictions to fundamental rights imposed here. You will see a lot of sedition issues here, Kedarnath here. You will see a lot of issues to Article 19 and exceptions added here. So today, the Parliament can amend anything in the Constitution. Constitutional amendments are not law. Anything in the 9th schedule, if it violates basic structure, can be challenged. And anything that violates basic structure can be challenged. Sometimes the Supreme Court has also used it to its own advantage. Independence of judiciary's basic structure, they used that principle to strike down the 99th Constitutional Amendment, which set up the National Judicial Appointments Commission. And the beauty is, basic structure does not exist. It's nowhere written. So if it's not written, how will the Parliament change it? The only way you can really strike basic structure down, if you have a minimum 13 bench or a higher bench of the Supreme Court, which seems very, very unlikely. Or the Parliament tries to take a backdoor route like the 42nd or the 24th Amendment, which also seems very unlikely. As an outcome of this judgment and several judgments, the judges who gave a judgment in favor of basic structure, and by the way, out of these 13 judges, only 7 favored basic structure and 6 did not, was a very, very narrow margin. It was an extremely narrow margin. One judge here and you would have not had the basic structure doctrine. And the judges who gave this, 2 of the most senior judges, one of them was supposed to become the next Supreme Court Chief Justice. Indira Gandhi didn't make him that. He resigned in protest. 2 other judges resigned in protest. Ever since we have a convention of the senior most judge of the Supreme Court to become the Chief Justice of India, Justice A.N. Ray, who was her favorite, who had given an anti-basic structure judgment. Also, with respect to certain emergency-related laws, Maintenance of Internal Security Act. Once this judgment came out, he set up a review bench of 13 judges to overrule case Ananda Bharti. But that bench was dissolved in 2 days. No one knows why. I don't have an official document as to why. These are the facts. And the concluding statements are, constitutionalism means restriction on the powers of the government. Through basic structure, you're restricting the powers of the government to make those changes to the constitution which are non-negotiable for this country. And if I have to choose between the integrity of the parliament and the integrity of the judiciary, unfortunately, I have to choose the integrity of the judiciary, even if they are an appointed office. Because the government has been very notorious with some of these amendments that they have tried to pass. They have a notorious history. The judiciary, on the other hand, doesn't. This is the basic structure doctrine. This is the basic structure case. So now, when we study plot number 2 tomorrow, we'll start from here. It will merge here. We will have the 25th amendment which will be added here. Case Ananda Bharti is also going to have an effect on plot number 2. And then the 42nd amendment, then the 44th amendment, and then Minerva Mills. A few things are going to be added. But this doctrine of basic structure owes its origin to land. And neither Keswananda Bharti got the land, nor Minerva Mills got, neither Golaknath got their lands. Keswananda Bharti was the leader of a Hindu religious congregation in Kerala, and their land was taken away under this Kerala Land Reform Act, which is why Article 30 was invoked. Religious land, but land nonetheless. Clear? Okay. Now, when you see the files that I have, the notes that I have given for you, see the kind of questions that have been asked. Basic structure is a part of your syllabus. See the kind of questions. The Supreme Court keeps a check on the arbitrary power, discussed critically. Then there was a question which is very similar to this. What is the IR Coelho case? Is judicial review important? And the Parliament's power is a limited power. Can Parliament under 368 destroy the basic structure? So what you actually get in the questions in the mains exam, right? What you get as a part of these questions in the mains exam are actually analytical questions. You'll find them right here. So, what is Article 368? How has it evolved over time? And whether fundamental rights can be changed or not is what has led to basic structure, and who can change them to what extent. This is your overall timeline. Your basic prologue, which I was talking about, there's a small error here. I will change it soon enough. This is with respect to Schedule 11. This should be Schedule 9, so you can make it, you can change it in your respective documents. Your two lines on each case. Then an analysis of the Keswananda Bharti case. What is it trying to do? Then Minerva Mills. Then your current Article 368 status, how has it been used? How was Keswananda Bharti used and the implications of it in the emergency? Your critical review that I have discussed with you. And of course, your analysis as to how does it work? Does it violate? Does it not violate? And is it justified or not? There you go. Done. Clear on this? Understood? Yes? Excellent. Excellent. I hope you enjoyed today's class. I really enjoy teaching this. This is good fun to teach. Okay.